On August 25, 2016, a judge in Campbell County, Kentucky, did something judges almost never do. He took a murder conviction he had personally presided over, a verdict he had already described in open court as cold-blooded, and he set it aside. No new evidence had emerged. No witness had recanted. The defendant had not been exonerated by science or by confession. What had happened was smaller than any of that, and in some ways, stranger. A lawyer working on the appeal had read through the jury list and recognized a name. 24 years earlier, she had represented that same man in a case involving unpaid child support. In Kentucky, falling far enough behind on those payments is a felony. And in Kentucky, a convicted felon cannot serve on a jury. The juror himself didn't know. He had checked the box on his questionnaire saying he had no felony record, and by every account he believed that was true. He didn't remember the plea. He had gone on with his life for 2 decades, was called for jury service like anyone else, sat through a 2-week trial, and voted to convict. That single administrative fact, a 1992 plea, forgotten by the man who entered it, erased a 2015 murder conviction and forced the Commonwealth of Kentucky to prove its entire case a second time, 6 years after the crime. That's where most people's understanding of this case stops. A technicality. Bad luck for the prosecution. But the retrial that followed is where the case actually becomes interesting, and where it starts teaching something. Why a forgotten plea can undo a verdict. Start with the legal question because it's the one viewers usually get wrong. The instinct is to say, so what? 12 people heard the evidence. 11 of them were unquestionably qualified. If the evidence was strong, why should a paperwork problem matter? The answer has nothing to do with whether that particular juror was fair. It has to do with a category of error courts treat differently from all the others. Most trial mistakes get measured against their effect. A piece of evidence that shouldn't have come in, a question that shouldn't have been asked, appellate courts examine the record and ask whether it plausibly changed the outcome. If it didn't, the conviction stands. Lawyers call this harmless error, and it disposes of the overwhelming majority of appeals. Juror qualification sits in a different category. The right at stake isn't a right to a fair-sounding verdict. It's a right to a properly constituted jury in the first place. When the panel itself is defective, there's no way to measure the harm because you'd have to reconstruct 12 people's deliberations to do it. Courts refuse to guess. Instead, the verdict comes apart. There's a real cost to that rule, and this case shows it plainly. 2 families waited 3 more years. Witnesses aged, memories decayed. And as you'll see, one witness's memory decayed so badly that her testimony had to be played to the second jury on video because she could no longer reliably tell anyone what she'd heard. There's also a cost to the alternative. If Kentucky had shrugged this off, the qualification rule would mean nothing in any future case, and the state would be deciding on a case-by-case basis whose jury had to follow the rules. Worth sitting with for a moment. The appeal succeeded not because of a brilliant legal theory, but because one attorney recognized a name on a list. That's how thin the margin can be between a conviction that stands and one that doesn't. The relationship and what the record actually shows. Ryan Carter Poston was 29 years old, an attorney practicing in the Cincinnati area, a graduate of Northern Kentucky University's law school. He had changed his middle name in law school to include his stepfather's surname, a small detail, but a revealing one about a young man who thought carefully about the people who had raised him. Shayna Hubers was 21. She was a psychology graduate working toward a master's in school counseling. They had met after he found her on Facebook in the spring of 2011. The relationship lasted about 18 months and broke apart repeatedly. Both juries heard a version of it, and the 2 sides drew that period very differently. The defense described a man who kept a younger woman on a string, pulling her close, pushing her away, humiliating her in public, imposing conditions on her, treating her, in her lead attorney's phrase at the retrial, like a yo-yo. Hubers testified that he threw her out of his condominium during one fight in April 2012 and injured her in the process. The prosecution described something closer to a slow-motion escape attempt. In the months before his death, Poston told a friend he intended to break up with Hubers face-to-face because hints and text messages hadn't worked. About 2 weeks before he died, a receptionist in his office building noticed he seemed low and asked what was wrong. He asked her how you break up with someone who doesn't want to break up with you. Then, he asked her opinion of men who need to apply for restraining orders. That second question deserves more attention than it usually gets, because it isn't really a question about restraining orders. It's a question about whether asking for one would make him look ridiculous. A separate witness, Poston's own cousin, testified at the first trial that he had told her the situation was reaching restraining order territory and asked her to intervene with Hubers. So here's a 29-year-old attorney. He knows the legal machinery for protective orders better than almost anyone in his social circle. He identifies his own situation as fitting that description. He raises it with two different people, and he does not file. The warning sign nobody is trained to read. This is the part of the case with the widest application beyond it. And it's the part most true crime coverage skips, because it doesn't have a villain in it. Research on stalking and coercive control consistently finds that men who experience it report at far lower rates than women do, and that when they do report, they're more likely to have their fear reframed as flattery, as a joke, or as a failure of nerve. The stereotype runs in one direction. Pursuit is something men do and women receive. When the pattern reverses, the vocabulary people reach for changes with it. Obsessed becomes clingy. Stalking becomes, she's really into you. Look at Poston's own phrasing again. He didn't ask whether he needed a restraining order. He asked what people think of men who need them. He was checking the social price before he checked the legal remedy. There's a second layer worth naming. Escalation in these situations is not steady. It tends to spike at the moment of separation, the point where control is being lost rather than exercised. That's a well-documented pattern in domestic homicide research, and it's the reason advocates treat the weeks around a breakup as the highest risk window rather than the moment the danger passes. The evidence at trial placed the shooting on precisely that boundary. According to the receptionist's testimony, Poston came into work that day upbeat, telling her he had a date that evening and that the relationship with Hubers was over. He had a first date scheduled for around 10 that night. He came home in the early evening, the prosecution argued, to change out of his suit. That is the most quietly devastating detail in the entire record. The reason he was in the condominium at all, on the state's theory, was a text message about a dress code. None of this proves anyone's intent. It does explain why investigators, once they saw the timeline, stopped treating the case as ambiguous. The couple living directly below Poston's unit became, without meaning to, the most important witnesses in the case, and they never saw a thing. Both of them told the same story independently at the first trial. Around 8:45 on the evening of October 12th, they heard 2 shots, then a pause, then 4 more. The wife put the pause at roughly 6 seconds. The husband described hearing the sound of someone falling between the two groups. Neither of them heard shouting beforehand. Neither heard the sounds of a struggle overhead. No thumping, no furniture moving. Nothing that a violent fight in a small condominium would be expected to produce through a shared floor. Why does a 6-second gap matter so much? Because self-defense, legally, is not a status you occupy. It's a justification measured moment by moment. Kentucky law permits force when a person reasonably believes it's immediately necessary to protect against unlawful force. The privilege exists as long as the threat does. When the threat ends, the privilege ends with it. 2 shots and 4 shots separated by a pause is not, on its face, a legal argument for either side. But it converts a single event into 2 events, and it forces a jury to evaluate the second one on its own terms. Huber's own account did not help her here. On the emergency call, she stated that after the first shots, he was still moving and making sounds, and that she fired again because she believed he was going to die regardless. She also told the dispatcher she had waited roughly 15 minutes before calling. She called her mother first. Prosecutors did not need to prove she planned the killing in advance. Under Kentucky law, murder requires intent, and intent can form in an instant. The defense's task was harder than the public generally realizes, not to prove she was a good person, but to convince 12 people that a reasonable person in her position in that room believed lethal force was immediately necessary and continued to believe it through the pause. Investigators found the physical scene difficult to square with her description. She said she'd been thrown into the television. The responding chief found it undisturbed and coated in dust. She described a reach across the dining table. Items on the table were undisturbed. An officer who examined her at the station documented no injuries beyond slight discoloration on one shin. The condominium was untidy, but Poston's father testified that his son was simply a slob and that he cleaned up there several times a week. That testimony did more work than its plainness suggests. It removed disarray from the evidence column entirely. The 3 hours that defined public opinion at the police station that night, Hubers asked for an attorney. Then, without being questioned, she began talking anyway, and kept talking for roughly 3 hours on camera. This is a point worth being precise about, because it's widely misunderstood. Asking for a lawyer requires police to stop questioning. It does not gag the person who asked. Statements volunteered afterward without prompting are generally admissible, which is why that recording survived every challenge and was played to both juries. On the video, she is animated. She moves around the room. At moments, she sings. She makes a callous joke connecting what happened to a cosmetic procedure Poston had wanted, a remark that would follow this case through every headline written about it for the next decade. When the recording leaked into local news coverage and spread online, it became the case, not the 6-second gap, not the dusty television, a young woman behaving unrecognizably in a small beige room. And here's where the documentary has to be honest, because the legal system itself is deeply divided on this exact question. Demeanor is famously unreliable as a measure of guilt. People in acute crisis behave in ways that look monstrous from the outside. They laugh, they go flat, they become chatty, they dissociate. Clinicians see it routinely. Innocent people have been convicted because a jury decided they cried wrong. The defense argued essentially that the recording captured a 21-year-old in shock, not a killer gloating. The Commonwealth's answer was narrower and ultimately more persuasive to two separate juries, that her statements weren't just a matter of tone, but of content, and that content contradicted the self-defense claim she was simultaneously making. The Kentucky Supreme Court, reviewing the retrial in 2020, addressed the related question of whether testimony about her apparent lack of remorse should have been kept out. It concluded the evidence was relevant to her state of mind, to whether she intended to kill or acted out of necessity, and noted, pointedly, that those remarks were probably the least damaging thing those particular witnesses said. The last observation tells you a great deal about how the second trial actually went. What changed in 2018? The retrial was not a rerun. 3 things were different, and each one moved against the defense. She testified. In 2015, she did not take the stand. In 2018, she did for hours. It was a defensible decision. The recording from 2012 was going to be played regardless, and a jury that only sees that version of you is a jury with nothing to weigh it against. But testifying meant cross-examination, and cross-examination meant walking through her own admitted conduct, hundreds of unanswered messages, letting herself into his home with her key, going through his phone, contacting his neighbors to learn whether he was home, using other people's phones to reach him after he stopped responding, faking a health condition during a breakup. Some of that she conceded directly. The jailhouse testimony expanded. 3 women who had been incarcerated with Hubers testified. Their accounts, if believed, went beyond attitude, that she had described deliberately making noise in the condominium to create the impression of a fight, that she had displayed self-inflicted marks to neighbors, that she had known about the date that night, and that she intended to claim abuse she hadn't suffered. Informant testimony deserves a caution flag every single time, and this documentary is not going to pretend otherwise. It is among the most cited contributing factors in documented wrongful convictions nationally. Incarcerated witnesses have obvious incentives, and juries are historically poor at discounting for them. A careful viewer should treat those 3 accounts as the weakest link in the Commonwealth's chain, not because the women were necessarily lying, but because that category of evidence has earned its skepticism. What's notable is that the prosecution's case did not depend on them. Strip all 3 out, and you still have the neighbors, the timeline, the physical scene, and the defendant's own recorded words. And time itself had done damage. The downstairs neighbor, who had testified so clearly in 2015, was by 2018 suffering significant memory loss. Her sons contacted prosecutors with concerns. The investigating chief visited and found she referred to 2012 as 2 years ago. The trial court declared her unavailable and allowed her earlier testimony to be played on video. Think about what that means in context. The retrial existed because of a decades-old child support plea nobody remembered, and the delay it caused meant a key witness could no longer remember either. The fight over where and the fight over what? 2 other battles from the retrial are worth understanding because they show how much of a trial is decided before opening statements. The defense fought hard for a change of venue, submitting dozens of affidavits from local residents. The case had been covered by national programs, the interrogation footage had circulated widely, and the argument was straightforward. This community had already made up its mind. The court applied a framework from a 2010 U.S. Supreme Court decision, weighing the size of the community, the nature of the coverage, and the time elapsed. Campbell County had roughly 92,000 residents. The heaviest coverage had run years earlier. The motion was denied. But look at the reasoning that followed, because it contains a genuine irony. The defense's strongest fact, that this case was covered nationally on network programs, streaming everywhere, was turned around. National coverage doesn't stop at a county line. If saturation coverage disqualified a venue, there would be nowhere in Kentucky to move the case to. Instead, the court did something more laborious. A written questionnaire mailed in advance, then roughly 15 hours of individual questioning of 82 prospective jurors, one at a time, in chambers. 61 had already been excused by agreement. 17 more were struck for cause. 1 juror knew she had been convicted before. Another had heard she'd gotten married while in custody. A 3rd had Googled the case despite instructions not to. The court kept some and excused others, and the appellate opinion spends dozens of pages explaining why, largely on the basis of hesitation. Jurors who wavered went. Jurors who answered flatly and consistently stayed. That's the actual state of jury selection in the modern era. Not finding people who know nothing. Finding people who can be pinned down. On evidence, the defense lost a fight it needed. It sought to introduce years-old messages in which Poston discussed his own prescription drug use, arguing the jury had to see him the way Huber saw him for the self-defense claim to make sense. The court allowed the post-mortem toxicology, allowed testimony about his medications, allowed evidence about a prescription refilled that day, but excluded the older messages as too remote in time and unfairly prejudicial. Reasonable people can disagree about that ruling. Self-defense puts the defendant's state of mind squarely at issue, and a defendant's fear is built partly from history. The court's answer was procedural rather than dismissive. Those messages could have come in through her own testimony or through a medical expert. just not, through the investigating officer. According to the appellate record, the defense didn't return to it. The arithmetic, nobody expected. Here's the outcome, and it is not the one anyone was arguing for. The second jury deliberated about 5 hours, nearly identical to the first, and convicted. It had the option of manslaughter in either degree or reckless homicide. It did not take it. Neither did the first jury. 2 separate panels, 3 years apart, hearing meaningfully different evidence, declined every available compromise. The penalty recommendation was life. In October 2018, the court imposed it. Now, the arithmetic. Under Kentucky's violent offender statute, someone serving a term of years for murder must serve 85% of it before parole eligibility. Her original 40-year sentence therefore carried a weight of roughly 34 years. A life sentence for the same offense is governed by a different subsection, eligibility after 20 years. She had also tried, after the first trial, to be classified as a domestic violence victim, a designation that under Kentucky law can lift the violent offender restrictions entirely. The judge rejected it. Added up, she won her appeal. She was tried again. She received a sentence that sounds far heavier and became eligible for parole substantially earlier. Kentucky Corrections records list that date as 2032. She remains at the Kentucky Correctional Institution for Women. The Kentucky Supreme Court affirmed the conviction in September 2020. What should a viewer take from this case? Not that the system failed, produced the same verdict twice, under scrutiny most trials never receive. And not, in fairness, that every question is closed. The abuse Hubers described was never disproven. Juries found it insufficient to justify what happened, which is a different finding. Both things can be true, that a relationship can be genuinely corrosive to both people in it, and that the killing at the end of it was not legally justified. What lingers instead is a conversation in an office lobby 2 weeks before anyone died. A young lawyer who understood restraining orders professionally, describing his own life in those terms, and then asking not whether he needed one, but how he'd look if he asked. Nobody in that building did anything wrong. They answered a colleague's odd question and went back to work. That's the uncomfortable part. The warning wasn't hidden in a file or buried in evidence. It was said out loud to 2 different people in ordinary language, and it registered as awkwardness rather than alarm. The forensic questions in this case were resolved in a courtroom. That one wasn't. Ryan Poston twice described his situation in terms of restraining orders, and never filed for one. How much of that was about the legal process, and how much was about how he expected to be perceived for asking? Share your thoughts below. Cases like this remind us that some questions continue long after the headlines fade. If you found this documentary informative, consider subscribing for more carefully researched true crime stories. We'd also love to hear your thoughts in the comments below. Thank you for watching, and we'll see you in the next documentary.